Viewers, welcome back to the show. Tonight we're going to be talking about class actions. Now, what is a class action, Nance?
Well, look, so, Tony, class action is effectively proceeding with more than 7 plaintiffs, effectively. And as I said, it's basically an action against the same person in relation to the same circumstances and basically arising out of the sort of same issues. And it differs from just the, plaintiff taking an action against an occupier or a company of some sort. It's more than 7 people. Has to be that requirement.
And John, some examples of recent class actions?
Well, currently, Tony, in Victoria, in the state of Victoria, we've got the bushfires class action, whereby people living in Kinglake, for example, they've issued proceedings against ISP, AusNet, the electricity company,
Department of Sustainability,
exactly,
Victoria,
for negligence in that the power lines have basically caused this firestorm.
They haven't been properly looked after.
Exactly,
Yeah.
and that's going to be a very long trial, isn't it, Tony?
Oh, it is. It is. 10,500 plaintiffs, by the way. Now, defining the representative group, you usually have one lead plaintiff. What does that entail, Nance?
Well, basically, it's finding that one plaintiff who's going to, be the front person or the face of the litigation, and it's important that in a class action that you find, I suppose, the best plaintiff who's going to represent you. And basically, all the plaintiffs in the background don't have as much of an involvement. It's that lead plaintiff plays the big role, Tony. So it's a very important.
That
role.
would entail a lot of vetting, wouldn't it?
It would, because you've got to know their history, and you've got to almost find the cleanest case and the easiest case to run.
Well, wouldn't you think that you need someone that's very articulate and can present a story, but in addition to that, you'd want someone that's got damages?
Yeah. And that the liability in respect of their claim is solid.
Yes.
Yeah, so...
And a credible witness at that.
And a credible witness.
These class actions wouldn't be cheap, would they?
Oh, no. I know, Tony. We're talking about literally, it could be 1 year of litigation in the Supreme Court of Victoria, for example. Now, you and I both know the costs of one day in court could easily be between $20,000 to $30,000.
Well, in a recent class action, there was over 20 barristers involved, of which more than half were senior counsel. That is a QC or senior counsel.
We're probably looking at over $200,000 a day, I would have
No,
thought.
more than that.
Exactly, Tony. And as you know, this type of litigation is on a no-win, no-fee basis.
Okay, that raises another issue. How do you fund these class actions?
Well, look, there's various ways of funding them, Tony said. Look, as John said, they're on a no-win, no-fee basis, but a lot of the law firms who do take class actions on would have funding, funding from other companies, whether it be litigation funders or those who just fund the disbursements. Look, they're such on high magnitude cases that you do need a funder because they cost millions and millions of dollars.
And I guess the byproduct of this funding litigation providers is they charge interest and set up fees, don't they?
Application fees and drawdown fees and the like. And look, they do make some good money out of it.
And this interest goes on, accrues daily. It's compound interest. It accrues daily. And in the end, the claimant does have to take that into account, don't they, Tony?
Exactly. How do you find out about a class action? How do you know that you want to jump onto a class action?
Well, Tony, technically, the court does order that publicity is provided by the law firm pushing forward this litigation.
Okay.
Now, and that's where the opt-in and opt-out issues come in.
All right, what's an opt-in? The opt-in provision, Nance?
Well, the opt-in is one that's utilised in the United States of America, where if you want to be a part of a class action, you need to opt in and obviously join that. Whereas in Australia, we operate under the opt-out system, where effectively, if a class action is commenced, you're effectively a part of it, and as long as once a settlement is reached and you register your claim, you're in.
Okay.
So it's more plaintiff friendly.
So the key is that you have to register.
Yeah, if a settlement is reached, you'll have to register. There will be terms and conditions.
What if you don't opt out? What happens then?
If you've registered and you don't opt out, you're part of the class litigation.
All right. Assuming you opt out, Nance, what happens after that?
We can take your individual case against the defendant, and if settlement is reached by virtue of the class action, you're not part of that, and you run your own litigation. And I think that's a dangerous move, because you've basically got all the work done for you.
For example, Tony, in this current bushfires litigation, by March this year, the court ordered that anyone interested had to register their interest.
Okay.
And if you had not registered by March this year, well then technically you're not able to claim damages.
So in the end, there'll be an amount awarded by way of damages, is that correct?
Yes.
And then how do they work out how you divide those damages?
Independent actuaries or assessors will assess the damage that you've received, and you may get a percentage of your damage. For example, let's say you've you suffered $100,000 in damage in total. You may receive 45 or 50% of that.
Okay. There can be structured in different ways. I've got a matter at the moment where my client's part of a class action, and the way they've structured settlements is that she's had 2 effectively surgeries, and they've based it on the amount of surgeries you've had. And if you've had 2 or more surgeries, you equate to $60,000. If you had 3 or more, it goes to $80,000, and that's the way her settlement's going to be achieved.
This word damages, John, what does it mean?
It's compensation, Tony. Compensation for pain and suffering, and maybe economic loss.
Okay. So when we talk about damages, Nuncio, we're generally talking about economic loss, which is loss of income, or property damage in the fire cases, and also psychological injuries in most instances.
And that's your pain and suffering, and the damages caused to you in your life.
Now, John, you're saying that you might only get 45 to 50% of the value of your claim. Why is that?
Simply because the quantum involved can never cover the whole damage that you've suffered. It depends in the end what the settlement or the court decision is. But we all know that most of these cases do settle, don't they, Tony?
They do. What we'll do is after the break, we'll go to that case of Mercica and IPS Osnet, where the total amount of damages was $78 million, and they settled for just under half of that. And we'll explain why. So viewers, please stay tuned. We'll be back shortly.